Welcome to today's webinar on the legal FDI implications of COVID in Europe and the United States. This event is organized by the European American Chamber of Commerce in New York, and where Americans and Europeans connect to do business. I am the Executive Director of the EACC New York, and I will be your host for today. About today's program, we will address the FDI implications that the COVID pandemic brought with it in Europe and in the US. And our panelists, Francesco Salerno, a partner at Gianni Oregani, Janine McGuinness, a partner at Oric, and the moderator, John Shames of E&Y, will help us to understand what has changed and which sectors and technologies are affected by the new rulings, how these changes will affect companies who are doing business on either side of the Atlantic. And the panel will also try to take a look into the crystal ball and explain what the new regulations could look like and how this issue may develop post the pandemic. With that, I will hand over to our moderator. John, the floor is yours.
Thank you, Yvonne, and good morning and good afternoon to everyone on this webcast. I'm delighted to be the moderator for this, and I have the easy job of really having a dialogue with our two esteemed experts in FDI and legal issues, both in the US and in Europe. Before we kick off, I just wanted to mention that, you know, when you really look at this in context of what we're talking about, this is a very robust relationship between Europe and as represented by the EU and the US. In the last couple of years, we've been around $3.6 trillion of US FDI into the EU, it actually peaked in 2017 and it came down in 2018 and 2019. EU FDI into the US is a pretty comparable number of $2.9 trillion, and actually that was a record. And so we're continuing to see increases into the US. Now, I should put this in the context of the fact that 2020 will see a major decrease in this due to COVID, that the experts right now are talking about 30 to 40%. And so when you really look at the countries involved, it's the countries that you would expect. The UK and Netherlands are the two biggest countries on both sides of the FDI equation. The UK for obvious reasons, Netherlands not as obvious, but mostly because there's a lot of tax jurisdictions based in Netherlands that are driving that. So those are the numbers that we're talking about. And so today we're really going to get into a conversation around exactly what is driving or what will drive FDI in the future. And I'm going to start out with Janine, who is going to talk about some of the legal issues around CFIUS and FIRMA. I guess we really can't have a topic without having a 5 or 6 word acronym or a letter acronym for these. So Janine, maybe you can explain these in more detail as to what these are and how do they operate for companies doing business in the United States.
Sure. Thank you so much, John, and thank you so much to the EACC New York for having us. It's a pleasure to be with all of you today. So just again, because we know some of you may have a lot of familiarity with CFIUS and others not so much, I'm going to start with sort of an overview of what it is, et cetera. So CFIUS stands for the Committee on Foreign Investment in the United States. And what this relates to is this so-called Exxon Florio law, which is a section of the Defense Production Act that authorizes the US president to block foreign investment in the United States for national security reasons and to order a divestment of completed transactions. Under the statute, national security is an undefined term, and therefore the US government has substantial latitude to interpret it broadly. And so this could pertain to the nature of the US party, the new US business that's being invested in, and also to the nature and nationality of the foreign acquirer. CFIUS is made up of the heads of major federal departments and agencies that include, among others, the Commerce Department, the Defense Department, Energy, Justice, State. It's chaired by the Secretary of the Treasury. And CFIUS has jurisdiction over transactions that could enable a foreign person, directly or indirectly, to gain control, essentially substantial influence over a US business, And in a recent change that we'll discuss in more detail, certain transactions that provide foreign persons with the direct or indirect non-controlling equity interest of basically of any size in a U.S. business that have if the U.S. business has certain critical technologies, critical infrastructure, or that collects what's called sensitive personal data. And also in the somewhat recent changes, CFIUS now has jurisdiction over certain real estate transactions in the United States. Most filings with CFIUS remain voluntary or discretionary, but the parties often seek CFIUS clearance to insulate a transaction from future interference from CFIUS or the president, because non-cleared transactions remain forever susceptible to potential interference. In the new scheme that we're under now, CFIUS filings are mandatory for two categories of transactions. Certain U.S. businesses and certain investments in U.S. businesses involved with critical technologies, and some types of U.S. businesses if a foreign investor has certain levels of foreign government ownership. And we'll discuss those a little bit later. So the focus overwhelmingly of CFIUS in recent years has been primarily on China and the perceived U.S. national security threats that are associated with Chinese investments in U.S. companies that have advanced technology or that have sensitive personal data, or in some cases that are near U.S. military installations. And CFIUS has played a leading role in a significant decrease over the past few years in Chinese investment in the United States. We've seen more and more CFIUS examining and disturbing completed Chinese investment transactions. The one that, of course, is in the news currently is what's being negotiated right now. President Trump issued an order for the divestment of TikTok by ByteDance, and we'll see exactly where that goes. But that's just the latest example of that trend that we've been seeing. So CFIUS, the traditional CFIUS jurisdiction is over control transactions. And control is not a black and white test. It's not a particular percentage interest. It's defined in functional terms as the ability to exercise certain powers over important matters that affect an entity. And so there's no bright line test. It can include minority interests and often does. And importantly, though, it's not deemed to be conferred by minority shareholder protections, certain minority shareholder protections like anti-dilution, et cetera. And small investments that provide certain governing rights to the acquirer or the investor have increasingly been determined to be controlling by CFIUS. And a U.S. business, and this is important for European companies to understand as well, a U.S. business is any entity, irrespective of the nationality of the people that control it, that engages in commerce in the United States. So if a European company has a U.S. subsidiary, then an investment in the European company could be subject to U.S. jurisdiction, to CFIUS's jurisdiction, at least in connection with the U.S. business that is the subsidiary. And so transactions between two non-U.S. companies can be subject to CFIUS's jurisdiction with respect to U.S. operations of the target company. Just for example, a few years ago, there was a Chinese company that was buying a German company called biotech, and that had plasma. That one had a U.S. subsidiary that involved plasma collection, et cetera. And this could not go forward until CFIUS reviewed it, and as a condition for the transaction going forward, CFIUS required that the U.S. plasma business be spun off and not sold to the Chinese company, and that was because of concern with the personal data that could be collected. So that's just an overview. We haven't even gotten to the timing of how long it would take, but let's move back to John so we can compare to the EU scheme.
Yeah, thank you, Janine. So Francesco, maybe you can talk about what is happening right now in Europe around FDI restrictions and limitations and regulations.
Sure, John, thank you. I think I will start from some of the things that Janine was saying, because there are clear similarities between the US and the EU. I think I'll start with the notion of control. I'm an antitrust lawyer, and the way I came into contact with FDI was precisely because in many transactions in which there was change of control hence antitrust filings, this went together with FDI filings. So I think the first point that these two systems have in common is that in transactions entailing a change of control, the issue of the FDI review may arise. I think that the second thought is about sectors. So not all transactions entailing a change of control are FDI reviewable. I think so. The second thought is which sectors are we talking about? And here I think again we have a point in common with the US in the sense that we also have a, let's say, military, defense, but the sectors also include transport, energy, telecoms. 5G also became reviewable, and then the list from 2019 already grew longer. Critical technologies, biotech, robotics, artificial intelligence, these have also become sectors which are reviewable. So it's a long list, and the difference when I heard Janine, one thing that is I think different is that filings are mandatory. So typically, as in antitrust, this is one of the things that you are obliged to do. In many jurisdictions, there are fines if you fail to do your filing, and also the resolutions which are adopted by a shareholder which hasn't been vetted through the FDI are null and void. So it is a system which is in a way strongly policed by the applicable statutes with effective sanctions. If I have just 2 more minutes, I'm joining here from Brussels, and that's the other reason I became involved with FDI. FDI is a national competence. So in the EU, each member state may or may not, it's not obligatory, but at least 14 member states have FDI rules. And this so that there are national procedures and national authorities enforcing their own rules. But from the 11th of October, we will have a new rule adopted at the EU level, so here in Brussels, which seeks to harmonize these different systems. And to harmonize them, I would say, in 2 ways. One is putting forward a list of the reviewable sectors. So by looking at that list, any non-EU investor will have at least a good sense of whether a transaction is reviewable or not. And the other thing that this new statute seeks to do is to increase coordination between parallel filings. So parallel filings will remain, but at least there will be more sharing of information between competent authorities in each member state. And hopefully, instead of getting twice the same decision mandating you to do something, maybe a decision in Italy will also cover what are the issues which are arising in France if you're buying a business that produces in Italy and sells in Italy and France. So these are perhaps the other big news that it's already very close on the horizon, is that there will be this other additional layer of EU regulation on top of national regimes. I think I'll stop there, and as we go through, we can develop these thoughts.
I had one question, or just a comparison, Francesco, with the U.S. As I had said, it's the test really is national security. But I think as we were preparing for this, you were discussing that the EU authorities can look at broader concerns, right? Some economic, et cetera.
Yeah, thank you, Janine. No, absolutely. I think the issues are certainly broader, and actually that, for example, the closure of a strategic business will be a reviewable transaction precisely because what it does, it harms jobs, for example, which would be a matter of concern for an FDI authority. It may take away valuable IP rights, for example. It may deprive a country of a capability to produce a strategic asset. So indeed, the concerns are broader, and when one thinks about what it takes to get FDI clearance, indeed, it takes a holistic perspective of what this business means for the specific country in which it operates.
So, Janine, let me pick up on that. In terms of, there's this definition of critical technologies, and you're talking about broad versus narrow. Where do you see this going based on history as well as kind of the expectations for the future? Is this becoming a broader screen, or is it being more specific under FIRMA, that it's just dealing with critical technologies?
Sure. So let's discuss FIRMA a little bit and exactly what critical technologies are and how FIRMA has expanded things. So FIRMA stands for the Foreign Investment Risk Review Modernization Act, which you can see why we call it FIRMA. That was in 2018, in the summer of 2018. And the final regulations for that became effective in February of this year, although there was a pilot program before that. And as I mentioned, it expands CFIUS's jurisdiction to certain non-controlling and foreign investments in critical technologies and then certain other areas, infrastructure, including power generation and sensitive personal data. And so with respect to these non-controlling transactions, this sort of goes a little bit to, not like in the EU, you're saying we were talking about the sectors. This is sort of showing what the US government is most concerned about, right? And so they've coined this new term called TID US businesses, the T for technology, the I for infrastructure, the D for data. And a non-controlling investment in one of these types of businesses is within CFIUS's jurisdiction if the foreign investor receives certain triggering rights. And that would be a board seat or a board observer seat, access to material non-public technical information about the infrastructure or technology, or involvement other than simply through their voting of shares in substantive decision making regarding the technology, infrastructure, or data. Critical technologies are defined in general as goods or services, software, or technical know-how for which a license is required to export them from the United States. There are also, or if it's ITAR controlled, the International Traffic in Arms Regulations, that's of course there as well. The Export Control Reform Act, which was passed at the same time as FIRMA, mandates the designation by the Commerce Department of emerging and foundational technologies for the imposition of export controls, especially in the area of artificial intelligence, computing, microprocessor technology. The US government is continuing to work on this, but as more of these technologies are designated, they will also become critical technologies for CFIUS purposes, and so therefore that will expand the number of transactions, even for non-controlling investments that will come within CFIUS's jurisdiction. Covered investment critical infrastructure is systems and assets that are like energy electric systems, facilities that provide electric power that to the grid or that are located near military installations. It could also include LNG terminals, certain pipelines, certain financial infrastructure, et cetera. And to be a covered investment critical infrastructure company, the business has to perform specified functions that relate to the infrastructure, like owning or operating or manufacturing, supplying, or servicing it. The sensitive personal data one has really become an issue. As I mentioned, it's involved with the TikTok one. It involves acquisitions of or investments in health companies that are doing, sometimes clinical trials. Sensitive personal data is identifiable data. That means that can identify a particular person within specified categories that's maintained by the U.S. business. If the U.S. business tailors it to certain sensitive groups like the military, or collects this sort of data on more than 1 million individuals, The specified categories involve certain financial information, insurance, health data, some geolocation data, some biometrics, and genetic testing. Identifiable data, as I said, is something that can be used to trace an individual's identity, such as a personal identifier like the person's name, email address, social security number, etc. So these are the sorts of things that we've seen really come into play and are really affecting a lot of the transactions that we're seeing. And then the mandatory filings really is one of the biggest changes that we've seen. So two categories are now subject to mandatory filing. The first is controlling investments in a TID business or a non-controlling investment in a non-controlling covered investment where the investor is getting one of those triggering rights in a TID business that produces or develops critical technology. The second prong of this is changing. Right now it is, they develop critical technology and it's used in one of 27 specified industries. But starting on October 15th, that regulation is changing. And so it will be, if there's critical technology, and it would require a US export license to be exported to the particular investor or to parties that have interest in that investor. There are, of course, certain exceptions to this in connection with certain types of encryption technology. There are certain exceptions and certain investments through investment funds. And if there's also an accepted investor category that we'll discuss in a few minutes. There are also the second category of covered investments for which there would be a covered transaction for which there would be a mandatory filing is where a foreign investor is investing in one of these TID US businesses. It's acquiring 25% or more of a voting interest, and a foreign government owns 49% or more voting interest in the foreign investor. So that's just a little bit of background on, exactly how, what these new regulations have done, and just to show that they're continuing to change.
So I would kind of take that and say this is pretty broad. I mean, it really does cover a lot of things, and it seems like the momentum is that it's going in that direction, that it'll cover more and more things. So, Francesco, we had talked about kind of how broad this is. How, given what Janine says, is what are the EU regulations even close to that in terms of detail? Or will it be expected that maybe over time that it will get to that point, given that maybe this is a little bit newer? Give us your perspectives on that.
Yeah, no, I listened with great interest to Janine, where she was describing a regulatory technique which sought through different layers to give to the investor a certain degree of predictability as to whether a transaction is covered or not. So in the EU, we are on the same track in the sense that so you have different layers. So in the, let's say, primary legislation, you have a list of sectors which is pretty broad. Let's say transport. And then you have secondary legislation which tries and breaks down that concept and explains that there are the tracks, that there are the railway station, and so on and so forth. But I think this has worked for traditional sectors, first of all, so energy, telecoms, and transport. For critical technology, and Janine was giving an excellent example. For example, that list in many member states is in progress, is an evolution. As the business itself, it's an evolution, so it's difficult to keep track. And it's defined maybe still with a certain degree of openness. And so there you need really, let's say, a functional interpretation. So I think the starting point is that it's more likely than not that a certain type of product is included. I think the sensitivity around a foreign investment is higher, not lower. And I think The other thing that we are seeing to, again, in an effort to increase predictability, is more dialogue with public officials. Again, I think this mirrors a little bit what we see in antitrust, in the sense that, you know, since filings are mandatory, there is also more and more a practice of pre-filing contacts. And so what the legislator has not been able to do or can do in the sense of giving clarity through the statute, there is the administrative practice that helps filing parties to have a feedback at the informal level as to whether the transaction is notifiable, yes or no. And this is again a reaction to the same trend we are seeing in the US, in the sense that the sectors are getting broader and broader, so the number of potential transactions is increasing, is booming. And so one of the reactions has been for the authorities to be more forthcoming, in the sense that they accept and welcome to have these pre-notification contacts. But indeed, I think we are on the same track, in the sense that the list is broad and getting broader, not narrower.
Yeah. Go ahead, Janine.
I was just going to say, I just want to make sure that everyone understands, like, these new rules in these sectors, you know, critical technology, critical infrastructure, sensitive personal data. That's, you know, now CFIUS has jurisdiction over certain non-controlling transactions in those spaces, but CFIUS has jurisdiction over the acquisition of control of any U.S. business in any industry. So in that sense, it's somewhat different than Europe. It's not, if you're only in this sector. And that's what makes it challenging for U.S. investors, because they say, okay, well, if I'm not in defense, and I'm not in one of, I've checked, I'm not in a mandatory filing, then they have to make a decision. Okay, well, this seems like it relates to some sort of technology. It's not that sort of, or it relates to telecom or whatever, and it's not a mandatory filing. But the U.S. government is interested in a large number of transactions, and that involve, anything from the energy space, as I said, to telecom, to financial institutions, et cetera. And so it really does behoove investors to think about these things in advance when they're considering investments.
Yeah, including real estate, right?
Exactly. As I discussed now, even just buying a building could potentially, depending on where it's located, be within CFIUS's jurisdiction.
Right. Hey, Francesco, just, two questions around this in terms of how broad this is and where this is going. But first is, where does UK stand in this, given that it's about to leave the union? And then secondly, there's been this dialogue around strategic autonomy, which is a new phrase that I've heard about the need, the interest of the EU to, as a bloc, maybe have more power or focus on its power a little bit better. Can you talk about these in the context of these FDI rules?
Sure. No, thank you, John. I think for the UK, and as long as it is a member, will be bound by this EU regulation I was discussing. When it leaves, it will have its own regime, which will be a continuation of what they have now. And in that sense, probably there isn't much difference with the current situation. They just won't have this additional layer of harmonization. They will then be bound exclusively by their own rules. I think the UK too has in a way share some of the concerns with the European partners, in the sense that especially at this time there is more let's say sensitivity around protecting technology from foreign takeovers. So I expect that their regime will resemble closely any major EU FDI regime. So there, I don't expect Brexit to bring any major change. The one thing is that a UK investment into the EU will be an FDI investment from the moment in which the UK leaves. So they will be subject to FDI scrutiny. But there again, if allow me to say one thing, in a way, the FDI rules really are an extension of rules that already exist between the member states, because Within the EU, there is free movement of capital, but that freedom is guaranteed for EU member states for intra-EU investment, but it is the only example of a freedom that is also guaranteed to third-party investors. So from the EU architecture, it's already an inbuilt open system in a way. So the rules, the FDI rules, really seek to stabilize a system which is already in place for intra-EU investment. And just to give you one small example, in Italy, for example, one of the most let's say prominent FDI event has been an investment by a French company into Italy. So that gives you an idea of how the FDI regime, that I think it's a bit of a contrast. We were discussing China before in the US. In the EU, I think this is not really specific to a non-EU country. This is something that has to do already with the investment of another member state into another member state, and then it has been expanded and extended to non-EU member states. So that is a little bit one message that I wanted to give, that this is a system that in a way, it's uniform. It seeks to treat all type of investments in the same way. I don't know if I answered your question.
Yeah, thank you. So let's move to obviously part of the title of this discussion was around COVID-19. And so I'd love to get some perspectives from you about what are the implications of the, currently where we stand with COVID-19 and the expectations down the road. And so why don't I start with you, Janine, on your thoughts there?
Sure. So initially, when COVID hit, in terms of just even the process, everyone was concerned that the CFIUS would be dramatically slowed down. And, obviously there can be some COVID-related delays, but we haven't seen that. CFIUS is up and working. They're accepting and clearing transactions, et cetera. The biggest lasting effects, and this has been widely discussed, will likely be on CFIUS scrutiny of foreign investments in the healthcare sector, and particularly in biotechnology, vaccine research, medical equipment and pharmaceuticals, and companies that are in related supply chains. There have been a number of bills that have been introduced in Congress that during COVID-19, none of which of course have passed yet, but that would sort of go to some of this. They're, with respect to one that was introduced in July, it was called the Agricultural Security Risk Review Act, and that would add the Department of Agriculture to CFIUS as a permanent member. And that was, again, somewhat concerned about like the food supply and just sort of other related crop growing, et cetera. There was a bill introduced by Senators Rubio and Warren, the United States Pharmaceutical Supply Chain Review Act, and it would direct the FTC and the Secretary of the Treasury acting through CFIUS to conduct a study of the US's over-reliance on foreign countries and the impact of FDI on the US pharmaceutical industry. There was also back in May, a bill, again, didn't go anywhere, but that was introduced on restricting predatory acquisition during COVID-19. And that would expand the scope of CFIUS review to purchases made by companies with ties to the Chinese Communist Party during the pandemic. So again, there have been efforts, and this will stay on the radar of Congress, et cetera, and CFIUS will consider these to be more sensitive industries going forward. With respect to distressed companies, CFIUS is also, and potentially buying distressed companies, CFIUS is definitely can play a factor. As I mentioned, that particular transaction that was sort of restricting predatory acquisition. The idea is to guard, and this is how DOD has put it, to guard against adversarial capital, as they call it, coming into the United States during the pandemic and related economic crisis, particularly as it relates to critical technologies. So, it's sort of a combination. They've got their eye on critical technologies, there may be even some small startup companies that have gone, are now distressed, and CFIUS is going to keep a watchful eye on, okay, is this going to be something where they're desperate for cash and it's an opportunity for one of our, rivals to come in and sweep these up. So it's not sort of like, this can go under the radar during this time. It's definitely something that's going to be front and center. There are also, in terms of, again, distress and the financial crisis with respect to CFIUS, when lenders foreclose on capital, on collateral, this could potentially implicate CFIUS in some cases. So, for example, if you have foreign lenders and they have a security interest in the stock of a particular company, that the foreclosure on that could become reviewable by CFIUS. It becomes reviewable at the time that, because of actual or imminent default or other condition, there's a significant possibility that the foreign person could obtain control of the U.S. business. And importantly, it's good to remember that transactions arising from bankruptcy proceedings can fall within CFIUS's jurisdiction as well. So during, if the restructuring departments in a particular law firm are reviewing certain transactions, they should be bringing in their CFIUS people as well. And if a foreign, European company is considering investing in a U.S. company that's distressed or potentially going through bankruptcy proceedings, they would be wise to consult CFIUS counsel and to consider the timing implications, et cetera.
Thanks, Janine. Francesco, what about the EU?
Yes, John, I think one change that the COVID brought about was to include in the scope a minority acquisition of minority stakes. And we started by saying that this is essentially about change in control, acquisition of control. I think one of the things that is COVID related is that now even minority stakes can be reviewable within the sectors we discussed. In many jurisdictions, this is a transitory rule that will expire, especially, for example, in Italy by the end of this year. But that is certainly one of the biggest changes that we have seen. I think perhaps slightly more lasting changes are about the way we look at the products within sectors, because for example, the health sector was already COVID reviewable, and now of course, if you produce these wonderful masks that protect us, now this is, and you acquire one of those businesses, that is certainly a reviewable transaction, no doubt about that. But if you'd asked me 2 years ago, I would have said probably not. So this is probably something that had also changed. And I think we also saw the concept of a predatory acquisition surfacing in the FDI space. The definition of a predatory acquisition is not so much related to the nationality of the buyer, but really to the fact of profiting from the fact that a company otherwise healthy is in financial difficulties. So it's listed on a stock exchange, so it becomes an easy target. And the reaction to that has been a tougher enforcement against this type of transaction, but also for those countries in the EU which don't have an FDI regime, there's been pressure on them to enact one and to use it also to protect against this type of transactions. I think on the positive side, we have seen perhaps a very, in a way, from the authorities, a willingness to cooperate, because at the same time, these are times in which FDI is crucial. And so while the sectors have become broader, the officials understand that bringing capital is essential for the economies to restart. And so there's a willingness to cooperate and work through the mechanics of the filings.
Yeah. And from a related question, because a lot of this kind of touches on this, and we talked before about, you really can't talk about especially U.S. relations, U.S.-China relations without, dealing with all these types of issues. And of course, it's becoming a bigger issue in Europe too. But I guess, Janine, just going back to you, if I'm a European company that's been doing business in the United States for a long time, CFIUS and FIRMA are really a challenge for me because of how broad they are. And and I'm sure companies are scratching their heads over going, why is this affecting me? I'm an ally of the U.S. and so I'd love your perspective on that and how much China plays into this and what do you do about it? And what can you expect to be different between, say, a German company doing business in the United States versus, say, a Chinese company that obviously doesn't cover this? But I'd love your thoughts.
Sure. So, well, certainly, as I mentioned, China has sort of been the impetus for some of the recent changes in the CFIUS regime, and allied countries will certainly be favored and not go through the same amount of scrutiny, et cetera. In fact, we don't have time to get into the details, but the U.S. New regulations do have this concept of accepted states and accepted investors. So right now, the accepted states are Canada, the UK, and Australia. That doesn't mean that investments from those jurisdictions are outside of CFIUS's scope, but certain transactions by certain parties with connections to those states are outside of CFIUS's scope and are also, in some cases, if they're within CFIUS's jurisdiction, are subject to or not subject to mandatory filing. There may be more accepted states added, and one of the criteria for determining whether they'll be added is, or the main criteria really is, the U.S.'s review and consideration of that country's FDI review process. So that's sort of, again, we want, and also cooperation with respect to national security issues. So with respect to some of the recent changes, I believe that they will be favoring European investors, certainly vis-a-vis, say, Chinese or Russian investors. I mentioned before that one of the changes to the mandatory filing, if there's critical technology, and if it's a covered investment, a controlling transaction or covered investment where the party's getting triggering rights, would be would be a mandatory filing if there would be a required U.S. export license for exporting that technology to the investor. Well, the European nations are subject to fewer export restrictions from the United States than, say, China. So in some of those cases, if they were, and it's already the case that if you had two bidders going after a U.S. business, from a national security perspective and an ease of getting through the process, it would be easier with the European buyer than it would be with the Chinese buyer. But this will sort of just even make that even more clear. So I would say that, it's not like a free and clear if you're from Europe that there's not going to be an issue, particularly if there's any Chinese investment in the European company. That certainly can play a role. I've seen instances where sort of there was an acquisition of a European company by a Chinese company, and then they had to remember that even if an acquisition were being done, say, by the German or the French company, CFIUS looks to the ultimate controlling parent, and so suddenly you're deemed to be essentially a Chinese party. So the Chinese concerns are not going to be going away in the future, notwithstanding whether or not there's a change in administration from the future.
Thanks. Francesco, from a European perspective?
Yeah, no, I think the concept of the accepted investor is something that in a way plays, in other words, the nationality of the buyer plays, in my view, less of a role in the EU. I think if you are a car lover and you think of Ferrari is built in Maranello, a little town outside Modena. So if your plan is to buy Ferrari, to dismantle this plant in Maranello and build it next to a Porsche plant in Germany, I think it's just as bad as if you wanted to put it in China. It's apologies for being facetious, but just to give you an example that the concerns around this type of transactions in a way do not change dramatically whether it's China or Germany. It's really the again, I'm oversimplifying. If it's strategic, then what the review is about is to understand what are the plans of the buyer. And this is really key to get an FDI filing over the line, and to explain, to be upfront with the authorities about what are the plans for this business. Is it going to continue being available, being boosted by the investment, or is it going to be dismantled and taken away? That, I think, is one very one has to anticipate that this is the way that the authorities are going to look at the given investment. I am on the same page in the sense that the authorities will look throughout the entire chain of control. So they won't stop to the vehicle that is buying whatever is buying, but they want to know, and if otherwise they will ask questions, but they will look at the entire chain of control.
Thank you. So I think you saw that to the audience, we've opened this up to questions from the audience, and I'm going to go through these, but please keep them coming. Francesco, I have one for you, which was really about, can you elaborate on the Greenfield US FDI into EU? I'm assuming this is around Greenfield infrastructure investments and how is this sector being dealt with from that perspective?
I guess the reference to green in the question has to do with the climate change and transition to a decarbonized economy. I hope that is the idea, and I think it makes sense because now there are essentially two priorities in the EU. Everybody knows about it. One is the green transition, the other one is digital. So I think any foreign investment in that space, my view is that first of all, it will be welcome on the condition again that the thinking is win-win, in the sense that the thinking is to become established in the EU and contribute to the growth of that business in the EU. So with that frame of reference, I think that the EU remains and will be an open economy that is welcomes foreign investment, and the FDI review will be successful. So that would be my answer to that.
Okay. So from a navigation perspective, so Janine, you're a US, you're a European company doing business in the United States. We talked about a broad range of things. What would be your advice to them? Obviously, you have clients coming to you all the time, and talk about some of the logistics and the mechanics around these filings and how long do they take, and how do you advise companies to deal with these?
Sure. So I would first want to say that the U.S. government, just to follow on what Francesco was saying, would say that it continues to be open to FDI, knowing that we do need foreign investment, and so it does welcome this. I would say to parties that are considering investing in the U.S. from Europe, and U.S. companies that are considering taking investment, to think about these CFIUS related issues early in the structure of the transaction, and they should be considering if it's a U.S. business getting ready to take investment, they should, if they have not already, classify their products and technology for U.S. export control purposes, because the first question the EU buyer is going to ask, or the EU investor, is, do you have critical technology? It's good to know the answer to that. And on the EU side, of course, you want to make sure you've got your diligence questions all set to go, so that you can analyze it. And so that's going to put more pressure on the export control regime and the export controlled nature of the products, even for technology companies that have never exported anything, and they may be just still in the development stage, et cetera. If the product is under certain export control classification numbers, then it would fall within the scope. So it's important to know that at the outset. I would say give yourself plenty of time, because It typically takes, we'd say for a non-controversial transaction, from the time you sign the deal, it could take 4 to 6 months. So let me break it down a little bit. Francesco talked about consultation, pre-filing consultation. You typically now in the U.S., if you're filing an ordinary notice, and that's sort of what's been the traditional way of making a filing, you file a draft notice with CFIUS a few weeks before, and you plan to make your final filing. You get some comments on it. You submit a final notice. They take a little bit of time to accept it. Then they commence a 45-day review period. At the end of the 45 days, they can clear the transaction, or they can put it into a follow-on 45-day investigation. Foreign government-controlled transactions are presumed to have to go into investigation, except under extraordinary circumstances. So in that case, that's another 45 days. So by the time you count up the pre-filing consultation and the time for CFIUS to make to accept it, et cetera, it could be 4, 5, 6 months. If there's something controversial and there needs to be mitigation in order for CFIUS to clear it, there's always the possibility that it could take longer. Assuming that it's not going to go to the worst possible thing, which is you have to abandon the transaction. But if you're negotiating with CFIUS for some mitigation, we've seen a number of circumstances where the parties withdraw and refile the transaction in order to give a little bit more time for them to come to agreement. So that would restart the clock. So that would make it longer. And there have been situations where things have been pulled and refiled numerous times. Now, under FIRMA, there is a new short form called the declaration, and that is a potential way to get to an answer faster. And how that would work is you don't really have to do the draft filing. You submit it to CFIUS and they accept it within about a week to 10 days. And then within 30 days, they have to give you an answer. But here's the trick. The answer could be, yes, you're cleared. The answer, or could be, we don't have enough information and we want you to submit a full notice. Or they could give an answer that says, we don't have enough information to make a determination, and you may submit a notice if you want. Or they could decide that they're going to actually start an investigation themselves, initiate a filing. So this offers the possibility of getting through more quickly, but it also, you run the risk that if they don't and they ask for a filing, if they don't clear it and they ask for a filing, that you've sort of lost that initial 30-day period. I'd say to be a good candidate for a declaration, you would want to be a repeat filer for a non-controversial transaction from a country that is considered to be an ally of the U.S. And probably, government-controlled companies in making investments would, want to think twice. It may not be the best, particularly during COVID, where resources are stretched a little bit. So, parties really need to consider and consult with their counsel in depth about which way to proceed. But as you can see, timing is important, and they can also consider ways to keep their transaction outside of CFIUS's jurisdiction. If it's a non-controlling investment, even if it's in one of those TID U.S. businesses, they can decide we're not going to take any of those triggering rights. We wanted a board observer seat, but now we're not going to insist on that because we want to be outside of CFIUS's jurisdiction. So it's important to explore these upfront.
Okay, thank you. Francesco, your perspective from a European view?
Well, there I join Janine 100%. I think to plan ahead, think early about the FDI is also key. Every jurisdiction is different, but in Italy, for example, you have 45 working days from filing to when you get a decision. There can be requests for information, which add another 10 or 20 days, depending whether it's to the party or to a third party. And this layer of EU regulation we were discussing before will add to that, because it essentially will mean that there are another 10 working days for another member state to submit observation to the member state which has received the FDI filing. So, and during that time, essentially, the buyer cannot exercise his rights. So it is important to get that process started on time to be able then to proceed with closing with the rest of the integration of a business. So certainly that thinking carefully ahead, it's important for navigating this system. The other thing that may be useful is that also in the EU, typically you can get, it's rare that at least, you know, blocking of a transaction happens rarely, because precisely the idea is not to block transaction, but it's to welcome investment, perhaps to issue mitigating orders. And so there again, your plans for the business going forward are important. If you anticipate the concerns, you may avoid getting plans imposed on you. So better to think about expanding that Maranello plant than to, you know, present the plan to move it somewhere else.
And these things, that's all very important in terms of negotiating the transaction documents too, right? I mean, these are risks. And so it's like, who bears the risks in certain cases? And, you know, whether you make, in the US, it's not, you're permitted to close before you receive CFIUS clearance. That's not typically done. But, you know, do you want to make CFIUS clearance a closing condition? What do you want the documents to say if you file a declaration and CFIUS comes back with sort of one of those no answers? Like, you need to think about all these things in advance. You know, what sort of mitigation conditions would you be willing to accept? Or what, if you're the seller, what will you insist that the buyer accept? So these are all things to be carefully negotiated in the transaction document. Oh, you're on mute now.
Thank you. We have a couple minutes left, and I just have one final question, and it's for you, Janine, and it's going to have to be quick. But I was expecting this before, but it was the first time it was asked. But it really was asking about if the Democrats took over the presidency and the Senate, what would your expectations be about, you know, how this would impact FDI going forward with Europe? And you get 1 minute to answer.
Sure, and the short answer is no significant change expected imminently. These are issues that the U.S. has been focused on, you know, before this administration, you know, particularly with respect to China. Some of these things were in terms of the scrutiny of Chinese investments was happening before that. With respect to the EU, you know, there continue to be, you know, more favored, and they will, you know, I don't think that, you know, a Democratic administration would really change that significantly, but you know, we will see. There are always bills that are being proposed in Congress, and it depends on who has the votes. So we will watch this space.
Well, that will be our next topic after November elections. I was going to say the date, but you never know when they'll be over. But so listen, I want to thank everyone and turn this back over to Yvonne to wrap up.
Yeah, thank you, everyone. That concludes today's webinar. A big thank you to our panelists for sharing your insights on this complex issue. And thank you to our audience for joining us for today's discussion. And in this virtual world, to enable networking, we will make a list of attendees available after the event. If you are a member of the EACC and you would like to connect to anyone on of the other participants, we will be happy to facilitate that. Enjoy the rest of your day. Thank you.
Thank you.